Hello. We are talking today about a difference between a protection mandate and a power of attorney. Why the question even? Because very often a protection mandate is a part of a power of attorney, uh, especially in the situations when it's given the just in case. So there is a general power of attorney, and the very last section of it usually it's a protection mandate or a mandate in case of incapacity, amounting basically to a stipulation that if I become incapable, then the same person should have the same powers. And that can bring a person, a holder of that power of attorney, into a serious legal trouble if the mandator, the person who gave the power of attorney, actually becomes incapable. So here is the difference. First of all, uh, it's true that sometimes a mandate in case of incapacity is as simple as a stipulation that the same power of attorney uh, goes further, but it's not a good protection mandate. A better protection mandate is a stipulation that if I become incapable, I would like to see this, and this guidelines applied to my property, this, and these guidelines applied to my personal well-being, my health treatment, my entertainment, bodily care, where I would prefer to live, and so forth. All those things that normally you do not stipulate in a general power of attorney because at the time you have your own free will to just take command of all those things. And even better protection mandate is usually a separate document, again, usually made, at least in Quebec, before a notary, with many particular stipulations and with a procedure to replace mandatory if something goes wrong or if that person can no longer be the mandatory, becoming, let's say, incapable him or herself, or just living to another province or another city, or who knows, many things. So if you have issued a general power attorney to somebody with a couple of paragraphs that in case of incapacity that all continues to be valid, well, don't think that it's enough. Many people say, and I agree with them actually, that a proper protection mandate is a more important document for you than a will, than a last will, because it affects your life at the most vulnerable point of it, if, of course, something happens. And it's not only about being mentally incapable, because accidents happen and some diseases happen even in a younger age, and, well, you never know. But having said that, like where the trouble for a mandatory comes from, uh, when somebody holds a power of attorney with a small piece related to the case of incapacity, that person has a tendency to assume that if the mandator, usually it's one of the parents or maybe grandparents or aunt or uncle or some old friend, if they gradually become incapable or diagnosed with some sort of dementia, that the mandatory could continue to use the very same document because it's said there, just like in case of incapacity. And this is where they make a trap for themselves, because the moment the person becomes incapable, or at least significantly weak in mind, the power of attorney is no longer valid. And if you continue to use that person's bank account, for example, or that person's property, even for the benefit of that person, of course, but you open yourself to a legal claim that you were negligent, grossly negligent, maybe even fraudulent, that you put yourself in a situation of conflict of interest, that you maybe just misappropriated funds and so forth. And usually in such a situation, you don't think of just keeping all the small documents, all the little receipts for whatever you spend. You simply continue to take care of that person the way you did before. But the trouble is there. And especially if there is somebody else who might later become an heir of that person who is like weak in spirit now. And if that person is not on like the best foot with you, and if you can envisage further at a certain point just conflict over some property of this person who is still alive but later will pass away, uh, then another person who would become a liquidator, an executor of the estate, might come after you, or the heirs might come after you. Or if you are the designated liquidator by the last will of the same person, the heirs who disagree with what you have done as a mandatory could go again after you and against you, saying that you are in significant conflict of interest and so forth. So the moment the person becomes visibly incapable, or at least you have some doubts about that, and especially if you have some doctor's confirmation of that, you should no longer use the power of attorney. But you cannot automatically start to use the protection mandate, the mandate in case of incapacity, because for the power of attorney, you only need that document signed and that's it. For a protection mandate to make it valid, you need a court homologation. You need that the court declare that person incapable and confirm the designation of yourself as a mandatory for that person. Without that, you cannot be in charge, basically in charge of the property, in charge of the personal decisions for that mandatory and so forth. So there is this gray area in between when the court has not yet homologated the mandate, but you can no longer use the power of attorney already. And in that situation, you have to ask the court for provisional measures, just to, if everything goes okay, to appoint you as a provisional administrator of the property until the mandate is homologated. So it's not an easy process, as you see, but if you just forget about that, thinking that, well, I take good care about the person, what else is needed? A lot is needed. And out of the best of your intentions, you could put yourself, your money, your property, your patrimony, something that could go later to your children or heirs. You could put all that in question because, from the legal point of view, you were improperly administrating somebody else's property. Sorry for this tautological phrase. So, while the mandator is capable, the power of attorney is enough, because the mandator is presumed to have control. The mandator could revoke it. The mandator could request some reporting from you. The mandator could even go against you in court if you did something wrong and so forth. So the power of attorney is enough. If the mandator becomes incapable, you need a court homologation. So, to summarize, the power of attorney becomes valid once it's signed and delivered to you. It might be a simple document, it might be a document made before a notary, it's all valid. Sometimes it's just to a specific thing, sometimes to a specific account in some bank, for example. Sometimes it's a general power of attorney, just whatever. Still, it's valid once signed and delivered. Of course, it's better to have it notarized, because some organizations, they require such a confirmation or certification, homologation even sometimes, just to protect their own responsibility. But generally, signing and delivering is enough. Not so with the protection mandate. And interestingly, a will, if signed before a notary in Quebec, becomes valid once the person dies, and it does not need probation in court. But the power of attorney, the protection mandate, even if it was made before a notary, it requires homologation in court because somebody's freedom is at stake. And it should not be an easy process to declare somebody mentally incapable, because by that court decision, that person becomes deprived from his or her own ability to make decisions for him or herself, either to a certain extent or completely. And instead, that power is given to somebody else, the mandatory. So it's reasonable that it's not easy to transfer, like exercising one's civil rights, from himself or herself to another person. So for power of attorney, a court order is needed. When you have a power of attorney, for the protection mandate, the court order is needed. For the power of attorney, is not. When you have a power of attorney, you report, or usually you don't even report, to the person who gave it to you. And only if that person suddenly dies, you, by law, have an obligation to make a final report to the estate of that person. But if that person revoked the power of attorney before he or she became incapable or died, then you might as well never submit any formal report for your actions. As long as the mandatory is satisfied, well, what else is needed? With the protection mandate, you have to report, usually annually, usually to a so-called tutorship council. Sometimes it's just the public curator of Quebec. Sometimes it's a group of people, relatives and friends of the incapable person. Sometimes some of those people are not in like best kind of relationship with you. Sometimes even hostile. Uh, Sometimes there are suspicions that you're using that person's money or property for your own benefit and not for the benefit of that person. Sometimes you even do that because you honestly think that you can, for example, live in that person's house while the person is moved to a long-term care facility. But the point is that in the eyes of the law, you are using for free the property that could be otherwise rented, and the money could be used for the comfort of that person in a long-term care facility. So often you think that you're not doing anything improper, but in fact you are doing. And you might be responsible because of someone's application or complaint about your actions to the tutorship council or to the public curator or both, or to the court, and your properly prepared financial report, regularly prepared, annually prepared, or even more often than that, that's your protection, actually. In case of a power of attorney, as I told you just previously, reporting might be or might not be required. In case of a protection mandate, it is required. So your actions, even if you're continuing to take care of that person, they necessarily become more formal. You have to remember that you're no longer just helping your parent or a grandparent or a brother or sister or friend. You're administrating himself or herself and their property. So you become a sort of an official. And when you agree to become a mandatory by the protection mandate, by the mandate in case of incapacity, think of it. Similarly, actually think if you agreed to become a liquidator to the estate, because it's not a simple task. There is a lot of paperwork, administrative work, and a lot of responsibility that is coming with it. Finally, when it comes to a power of attorney, it's easy to revoke it. Basically, the person can either just take it back or declare or give the power of attorney to somebody else and stipulate there that he or she revokes all the previous powers of attorney. In certain situations, that matter could inform the bank, for example, that that power of attorney is revoked. But that's it. Again, there is no need for anything else. Sometimes the mandator could simply tell you, okay, give me the old one, I'll give you another one where something is changed or some stipulation is made or some powers are revoked or added, and so on. That is it. But when it comes to a protection mandate, whatever is there stays there, and by the time when it comes in question, the person can no longer amend it, can no longer proceed with any modification because that person is already weak in spirit. So, to do any modification to that, you necessarily will go to court and ask the court to modify, and you'll have to explain and prove to the court that it's actually necessary. And if there was a specific limitation in the protection mandate, for example, as to the place where the person wants to live, because mostly people don't want to go to a long-term care facility voluntarily, and you think that staying in the family house becomes dangerous to that person because, well, there is not enough money to provide constant 24 hours per day or observation and care for that person in there. So you will think that the person should be moved to a more specialized facility. Then if it goes against the protection mandate, you would have to ask the court authorization to do so. And to the contrary, sometimes you do everything by the mandate, but other relatives or friends think that it's not enough and that something else should be done, and they could go to court and impose additional restrictions or additional actions and so forth. Also, at a certain situation, for example, you might think that some significant expense is to the benefit of the person you are taking care of, but potential heirs, well, caring about their own inheritance, might go against that. And if the protection mandate is not specific, then you might, again, to protect your own responsibility, might need to go to court and so forth. So you see how it is much more cumbersome because for the power attorney, the mandator is deemed to be in full control. And it is presumed that whatever you're doing as a mandator, if the mandator does not go against that, then it's done with the blessing of the mandator. But when it comes to protection mandate, there is no such a presumption because the person, to the contrary, is presumed to be not capable to control and give his or her consent. Therefore, you have to tread much more carefully. So basically, these are the main reasons why, if you have a power of attorney with a stipulation in case of incapacity, that you should not easily just continue to use the same document if the person, the mandator, becomes or gradually is becoming incapable. You should consult a doctor, you should consult a social worker, you should consider if you wish to continue with this added responsibility, and if you agree to that, you will have to proceed before a court. Thank you and have a nice day.